Hi, everyone. I'm Andrew Price, and I'm joined today by my partner, Rafe Schaefer. Welcome to another edition of Texas Business Court Insider. In this episode, we are going to cover two cases further defining the court's jurisdictional contours. And the first case we're going to talk about is Barrett versus Barrett. And the issue in that case was whether or not the business court had jurisdiction over removal of a matter from probate court. Rafe, tell us a little bit more about the facts of that case.
Sure. So the plaintiff was Charlotte Rogers Barrett. She was the beneficiary and trustee of the Charlotte Rogers Barrett Trust. She sued in probate court. She sued various family members as individuals and also as former trustees, along with various related partnerships and LLCs. She brought kind of the panoply of claims for breach of fiduciary duty, self-serving investments of trust assets in family-run business entities. And she sought various types of relief, some of which are directly relevant for the argument for business court jurisdiction. She sought modification of a trust. She sought monetary damages to recoup trust losses. She sought disgorgement of profits from the defendants and what they gained through breaches of fiduciary duty. She sought judicial dissolution of a partnership. She also sought attorney's fees and some other declarations. But based on the fiduciary duty claims and the dissolution of a partnership, one of the defendants, Marcus T. Barrett IV, removed the case to the Texas Business Court. He argued that those dissolution and fiduciary duty claims were claims regarding the governance and internal affairs of legal entities, and thus that the court had jurisdiction. Andrew, what was the court's ruling?
Well, the business court remanded the case, and it found that it lacked jurisdiction, and it engaged in what it's done several times before, some statutory construction, and it found that the granting statute was clear and unambiguous. And basically, without further kind of legislative changes to its jurisdiction, it could not exercise jurisdiction over the plaintiff's claims in this case. And what's interesting about that is, as you just kind of outlined, there were a lot of claims in this petition that, practitioners, I think, would find right in the business court's wheelhouse. There were, the plaintiff in this case had specifically pled derivative claims, had alleged that the defendants had breached their fiduciary duties to the various business entities. Exactly the types of claims that the business court is uniquely positioned to handle. But again, the business court said, we are a statutorily created court. Our jurisdiction is constrained by statute. And the statute here simply says we cannot take this case. Why? Because replete throughout the petition were references to the estate code and Title IX of the property code. And the granting statute for the business court makes very clear that cases and claims that arise out of those statutes cannot be in business court. And so in determining whether or not the claims actually fell under it, the business court conducted an analysis and said the crux of these claims that the plaintiff is making arise directly out of these statutes, and therefore we lack jurisdiction. So they remanded the case.
You're right, Andrew. It's a really interesting opinion, especially in light of cases that we've covered previously, like Reed v. Rook, where the court looked at the allegations and really kind of pierced the cause of action to look at whether the allegations were allegations regarding internal affairs, regarding corporate governance, or regarding governing documents, and where the factual allegations were regarding those allegations or regarding those components, the court had found jurisdiction and had ruled in favor of jurisdiction broadly. But here, the court looks directly at whether claims arise directly out of the probate code or the estate code or the property code, or whether the crux of the plaintiff's actions. And so it really, I think, sets up a test that's going to be applied going forward of, even if you have claims that are regarding items that the court has subject matter jurisdiction over, if one of these exceptions applies and the crux of your petition is under a statute that the court does not have jurisdiction over and expressly cannot adjudicate, that's going to trump, other more general allegations of jurisdiction and send you back to district court or probate court.
Yeah, the carve-outs are really a blocker. They're just really a blocker to the exercise of jurisdiction.
I just mentioned the Reed v. Rook case, Andrew, which I know we did a video on several months ago. Speaking of Reed v. Rook, Andrew, what's the second case we're going to discuss today?
Well, it's Reed v. Rook. It's back. And as you mentioned, we did a previous video on this. Folks who don't remember it or didn't watch it should go back and review it. Super interesting. But to preface Reed v. Rook 2, which we're going to talk about today, let me give a quick recap of the facts before I turn it over to you to talk some more about the case. Reed won the lottery, Texas lottery, in May of 2023. His lawsuit alleged, I would have won $95 million more if the defendants hadn't illegally manipulated the lottery to win $95 million. So I should have gotten all the money. I had to share it with the defendants who had manipulated the lottery. And the allegations regarding manipulation of the Texas lottery involved some arguments relating to the false formation and misrepresentations about the creation of a general partnership that the plaintiff alleged the defendants used to manipulate the lottery and to receive the proceeds of their lottery win. And based on the arguments and allegations about the false formation of the partnership, the business court exercised jurisdiction originally over the case and denied a motion to remand because the business court held that the claims asserted by Reed were all regarding governance of an entity, the governing documents of the entity, and the internal affairs of the entity. What happened in Reed v. Rook 2, and why are we talking about it again, Rafe?
Sure. So after that ruling, Reed went back and amended his petition and then amended it 3 more times in a total of 4 amendments in what appear to be various attempts to get out of the business court. The 4th amended petition, Reed went in and omitted all previous allegations to false or fraudulent formation of Rook GP. He disclaimed all those allegations. He only kept his previously pled money had and received claim. He added some other claims like tortious interference with prospective business relations, but as far as his prior allegations went, he basically dropped all of them and disclaimed them. Interestingly, when defendants responded to the new motion to remand, defendants conceded that by removing those allegations, the court no longer had jurisdiction under 25A.004B where it had previously exercised jurisdiction. The defendants, though, asked the court to either exercise supplemental jurisdiction or to find that the court had jurisdiction as a qualified transaction based on the tortious interference with prospective business relations claim that the plaintiff had added. How did those arguments go, Andrew?
Well, the defendants' attempts to kind of pivot and make these new jurisdictional arguments didn't work, and the business court has remanded the case now. And the bases was kind of as follows. Big picture, the business court says this case is an example of, the maxim that the plaintiff is the master of his or her complaint, and that Reed had effectively divested the business court of jurisdiction by, as you described, stripping out all of the allegations that had previously formed the basis of the business court's jurisdiction. And we'll come back to this in a minute, but you mentioned it. And the business court noted, hey, the defendants have conceded that the prior bases on which we exercise jurisdiction no longer exist. But the business court went further and addressed these new arguments, said there is no supplemental jurisdiction over the case because supplemental jurisdiction is kind of by agreement, and there had never been agreement. The defendants had been trying to remand this case from the beginning. They had always contested jurisdiction of the claims. And the court also revisited qualified transaction jurisdiction. It rejected the idea that there was qualified transaction jurisdiction and relied on another case we've discussed in other videos, G-Force. And G-Force was a construction bid case. And in that case, the business court had held you've got to have a consummated transaction, not a prospective transaction. You have to have a consummated transaction for it to be qualified transaction jurisdiction. Just like in G-Force, there was no consummated transaction here. Therefore, there's no qualified transaction jurisdiction under the business court. So it's now sent the case back to district court. Rafe, let's come back to this idea of the concession and talk a little bit more about that.
Sure. I feel a little bit, Andrew, like, when you show up to 1L Civ Pro class and you've read the case and you're ready to talk about the case, and the professor says, forget the case, I want to talk about footnote 2. I want to talk about footnote 2 to Reed v. Rook 2, because the court devotes a lengthy footnote 2, to the question of whether a pleading amendment, like Reed's fourth amended petition, can divest the business court of jurisdiction. The court cites various cases on both sides of the issue. It goes through cases on amount in controversy, including Texas state court cases that ruled that changes to amount in controversy made after a court exercises jurisdiction can't divest the court of jurisdiction. It also goes through federal court cases where, sometimes a late joinder of parties can divest a court of diversity jurisdiction, or dropping a federal question claim can divest a federal court of federal question jurisdiction. And it basically opens this issue up, but it doesn't decide the issue. And it says because defendants didn't insist on the court continuing to have jurisdiction under Section 25A.004B2, where the court had previously found jurisdiction, defendants have dropped that jurisdictional basis. Defendants aren't asserting that jurisdictional basis anymore and concede there's not jurisdiction there. And so the court only looks at the jurisdictional bases the defendants asserted in response to the renewed motion to remand and says, I've never had supplemental jurisdiction and I've never had qualified transaction jurisdiction. And therefore, since I've never had jurisdiction under the new jurisdiction pled by defendants, I don't have jurisdiction and I remand the case. The court expressly says it is not deciding whether an amended pleading can or would divest the court of jurisdiction. I think that's a really interesting component of the opinion, Andrew. What are the takeaways for go forward practice?
Well, I think there's a couple of big ones. One, don't concede that your prior jurisdictional bases no longer exist simply because of a pleading amendment. I think that's the first thing. Some defendant is not going to concede it, and then we're going to get an answer to this question of whether or not that works, that attempt at repleading works. And then secondly, the footnote that you highlighted, regardless of how that issue comes out, there could just be issues of when the court is going to allow repleading to divest it, or when just other things that happen in the case or come out in a life of a case are going to cause the business court to revisit its jurisdiction. And so, the footnote that you mentioned, in the body of the opinion, the sentence that footnote is tied to is Now, although later events generally do not divest a court of jurisdiction once properly acquired, Reed has successfully pled his way out of this court's jurisdiction by removing all such claims from his pleadings. I am confident that there are going to be plaintiffs who get removed to business court that are going to try to do exactly what Reed did and cite that language, and it's going to get litigated. And so it'll be interesting to continue to keep an eye on this.
For sure, and we will continue to do so. Thanks, everyone, for watching. The Texas Business Court Insider will continue to keep you updated on developments in the Texas Business Court and beyond. Don't forget to hit like and subscribe so you'll be notified when our next video drops.